Yes, Your Honor. This matter has been adjourned a couple of times. The balance owing is basically stemming from pet fees and a pet deposit for an animal that Ms. Bell had. The question that's presented is the application of ESA. Back in 2019, Ms. Bell applied for an ESA for a dog, I believe it was a pit bull. She had a letter from her doctor indicating the need for the support animal, and it was granted. At that point in time, she did not pay a pet fee or a pet deposit.
Right out of the gate, this hearing is already heading into dangerous territory for the landlord. The court is hearing that back in 2019, the tenant properly submitted documentation for an emotional support animal, the request was approved, and management waived the pet fee and deposit. That sounds simple on paper, but what makes this explosive is what comes next. Because once a landlord recognizes ESA's status, the legal foundation changes completely. This is no longer just about pets. This becomes a fair housing issue, and judges take those very seriously. Now listen carefully to the tension building here. The landlord is trying to frame this as a routine certification problem, while the court is already starting to focus on consistency, policy, and authority. And trust me, once a judge starts asking, "Where exactly is your authority to do this?" that is not the direction property management wants this hearing going. This case is quietly shifting from pet paperwork dispute into a potential discrimination and fair housing nightmare, and neither side fully realizes yet how messy this is about to become.
Subsequently, I believe in February of 2023, she had to remove the support animal because it was a pit bull and it apparently had bitten one of the tenants. That was in February. She replaced the animal, and then in October of 23, we requested that she certify the new animal, which I believe is Pride Chihuahua. And
well, let me ask this, because I remember the issue, but the certification for the animal, however one wants to put that. Well, let me put it this way. Does the complex certify the animal?
The complex asked that she read certification that of her needs for the support animal, which in 2019 she did provide for us. We asked starting in October when she got the new animal, we asked that she recertify herself that she had a continuous need for that support animal.
Okay, and again, that I guess brings me to the next point. If nothing had happened with the pit bull, she wouldn't have had to recertify anything.
Well, we take the position that we could have asked her to certify, but we didn't. The fact that she had the replacement animal brought it to our attention. Does Ms. Bell still need a support animal? If so, we asked that she be recertified. We asked, and I have if I can present to the court.
And here comes the classic courtroom pivot. Once the direct legal authority starts looking shaky, the strategy shifts toward emails, conversations, and ongoing discussions. But Judge Simpson is clearly not interested in whether people talked about the issue behind the scenes. He wants something much more dangerous for the landlord, a concrete basis for the request itself. Notice what the landlord's side is trying to establish here. They're attempting to argue that because the original pit bull was removed and replaced with another dog, management had the right to revisit whether the tenant still needed an ESA at all. Sounds reasonable at first glance, right? But the judge immediately sees the crack in that argument. Because the ESA approval wasn't attached to the dog, it was attached to the tenant's documented need. Huge distinction. Massive distinction. And the court is beginning to realize the landlord may have blurred those two concepts together. That's the danger in hearings like this. One procedural misunderstanding can suddenly evolve into a fair housing exposure issue that costs way more than a disputed pet deposit ever could.
If I may approach, Your Honor.
What are those?
This is a thread of emails between Group 5, Group 5's attorneys who was handling the case then, and Nikki Green from Fair Housing, talking about the pet situation. And Nikki Green basically said she was going to follow up with her doctor, I think Dr. McAvoy, to see if we can get the certification. According to our information, Dr. McAvoy refused to do the certification. We asked that she possibly
but was
get
that the
another
previous doctor?
Hmm?
Okay,
I'm sorry.
but here's my issue with this. When she did that in 2019, she's not certifying the animal.
Correct. She's certifying her need for an animal.
Right. So what would lead the complex to think that changed?
Well,
Because and the reason I'm asking that is because based upon at least what's been represented to the court, the only thing that happened is the removal of the animal.
that brought it to the attention of management that does she still need a support animal? And that's why we requested a certification.
Why would that raise the issue?
That question right there just changed the entire momentum of this hearing. Judge Simpson is no longer casually exploring facts, he's now openly challenging the landlord's logic. And when a judge starts repeatedly asking why, it usually means the explanation being offered isn't landing. The landlord is basically arguing that the replacement of the dog triggered concern about whether the tenant still needed emotional support assistance. But the court keeps circling back to one devastating point. For years, nobody asked for recertification. Not in 2020, not in 2021, not in 2022. Suddenly, after the original dog is removed, management decides the need itself should be questioned. That timing looks bad, really bad. And you can feel the judge trying to determine whether this was an actual policy or simply an improvised request made after management became uncomfortable with the situation. Courts hate inconsistency because inconsistency opens the door to claims of unequal treatment. At this point, the landlord's side desperately needs a written policy, lease clause, recurring procedure something. But so far, nothing solid has surfaced.
Well, I believe there's a difference between an ESA and a service dog. A service dog, if you're blind or
Right.
handicapped, you apply for a service dog. That's a different type of certification. And at that point in time, if it's granted, basically it's for life. Support animal is different. It's like,
Well, what explains to the tenant that it's different? I mean, because from what I'm hearing, and correct me if I'm wrong, in 2019 to 2020, in 2020, the dog is still there and she doesn't have to do anything. The dog just continues there. 2020 to 21, same thing. 2021 to 2022, same thing. So I'm looking at a 3-year period where she has to do nothing. She has this dog.
we didn't raise that issue at that point in time, but
Why, though? I mean, what makes not raising the issue at that time as opposed to raising it later on? What's the distinction
well,
if you're not certifying the animal?
I believe that in a situation that the complex has the right, and there's nothing in the law either way, that we have the right to certify, recertify, or we don't have the right to recertify. So it brought us to the attention, does Ms. Bell still need certification? And it's a simple process. All she had to do is go to the doctor.
But I get that that's the process that the landlord wants her to enter into.
Correct.
Watch how carefully Judge Simpson is dismantling this argument piece by piece. He's not yelling. He's not being dramatic. He's doing something much worse for the plaintiff. He's forcing them to explain the logic repeatedly until the inconsistencies become impossible to hide. The landlord keeps emphasizing that recertification is a simple process, but the judge doesn't care whether it's simple. He cares whether the landlord had a legitimate basis to demand it in the first place. Those are two completely different legal questions. And honestly, this is where a lot of housing disputes collapse. Property management often assumes that because a request seems reasonable internally, that automatically makes it enforceable externally. Courts don't work like that, especially when fair housing protections are involved. Now the judge is zeroing in on timing. Why ask after years of silence? Why wait months after the new dog arrived? Why no standardized review process? Those questions are stacking up fast, and every answer seems to create two new problems for the plaintiff. You can already feel the courtroom momentum leaning heavily toward the tenant here.
Problem that I'm having with this is why was the request made at that time as opposed to being made at every 6 months, every year, every whatever?
Well, the dog was, the pit bull was removed in February of 23. We waited 8 months. She got a new dog. We waited 8 months until October of 23 in order to give her some time to get the certification. At that point in time, we formally requested it, and that's when we started
Okay, but when
assessing.
did the new dog come in?
Excuse me.
When was the new dog?
I can tell you all of that real quick because my mother doesn't even really sure of it. Faithful was moved out of the house in April of 22, not 23.
Okay,
She got
that's
home
fine.
in December of 22. You all got the wrong dates. I don't know
It
why.
doesn't, ma'am, I don't need that.
Okay.
If the dog got removed February, April,
Mhm.
when did the new dog show up?
December of 22. December of 22.
Yeah, it was 8 months after the old dog was removed.
And then when was the request made for the new?
In October of 23,
So,
I believe.
so was that the first request for the
For
DS?
recertification, yes. In October of 23.
So why did that happen then?
Why? Because at that point in time, we reviewed our records and we said, well, does Miss Bell still need the dog?
Oof. That answer did not help the landlord at all. The judge is asking for a concrete trigger, some policy, event, lease provision, recurring review requirement, anything that explains why management suddenly decided to revisit the tenant's ESA status almost a year later. Instead, the response basically boils down to, we reviewed the records and wondered if she still needed the dog. That's exactly the kind of vague, discretionary reasoning courts become uncomfortable with. Because once there's no defined standard, the next question becomes unavoidable. Why this tenant? Why this moment? Why not everyone equally? And you can see Judge Simpson starting to realize the plaintiff may have accidentally stepped into a much bigger legal problem than unpaid pet fees. The more the landlord talks, the more the hearing starts sounding less like enforcement of a neutral policy and more like selective scrutiny. Question for you, watching this case. Do you think landlords should be allowed to periodically recheck ESA documentation whenever they want? Or should there have to be a written rule in place first? Because that issue is now sitting right at the center of this hearing.
And
So-
that's when we,
Whoa,
that's,
whoa. No. I'm just trying to sort this out. Because this doesn't make much sense to me. The pit bull gets removed February of April, whichever it is, of 2022. Right? The new animal comes in December of 2022. Right? And the request for this is effectively a year later, 10 months later,
correct.
by the landlord.
Yeah, I understand what this court is struggling with, but if you take a look at, comparable laws like workers' comp, not social security, or disability insurance, they have the right to review the continuing disability every so often, every 6 months.
But you're not reviewing her disability.
Yeah, by asking her for recertification, we're asking.
Where in the lease does it state you could do that? I mean, because
It doesn't.
that's the problem. The problem
We're dealing also with the law, Your Honor. The law is unclear on it itself. The fair housing, as it pertains to ESA, and I checked into it. There's
Okay.
no.
I get that. I understand the complexities or absence thereof. What I'm looking at the circumstances of this.
And there it is. Judge Simpson is now openly framing the timeline against the landlord. Listen to how methodically he lays this out. The original dog remains for years without issue, the replacement dog arrives, management still says nothing for nearly another year, and then suddenly recertification becomes urgent. The court is practically building the tenant's argument in real time. What makes this dangerous is the appearance of inconsistency. Judges know policies don't have to be perfect, but they do need to be predictable. If tenants can't reasonably know when requirements apply, enforcement starts looking arbitrary. And arbitrary enforcement is exactly where fair housing disputes become extremely expensive. The plaintiff's attorney keeps trying to argue that the law is unclear surrounding ESA recertification, but that ambiguity may actually be hurting them more than helping. Because if the law is unclear, then the landlord really needed a clearly structured internal policy to justify these demands. So far, the court hasn't seen one. At this stage, the landlord isn't just losing control of the argument, they're losing control of the narrative entirely.
So one thing that's very clear to me is, had the pit bull remained, there wouldn't have been a request.
Maybe.
Well, there wasn't.
There wasn't.
There wasn't. Right?
Yeah. But
Pit bull gets removed, a new dog comes in, and when the new dog's there still is no request.
At that point in time, no. I
Then
think
10 months later, effectively, almost 11, really, I guess, depending on when in the month these things are occurring, 10 to 11 months later, there then is a request.
correct.
And I'm trying to figure out, why was that request made?
It was brought to our attention that, does Miss Bell still need a support animal?
Brought to your attention by whom?
It was brought to our attention in the review of the record. A review of the record, when we found out that she had the new dog, we asked that she recertify herself as a need for that support animal. And it's a simple, I understand the court, but it's a simple process. And according to the.
But why would you ask? That's my question. I'm not so much concerned about what the process is. I'm not concerned about what happened, didn't happen. Why would you ask?
It was a review of the records showing that she has a support animal. Does she need a support animal?
But hold on a second. When was the landlord aware of the new animal?
This is Kurt Herbeck. He's the.
When was, I just need an answer.
October.
October of what?
23. That's when she was first charged, SB.
No, I'm not saying a charge. When does the landlord know she has this new animal?
I think it was sometime in 2023, according to the email threads I'm looking at.
This hearing is now spiraling into one of the worst situations possible for a plaintiff in housing court. The judge is no longer debating whether the tenant complied. He's questioning whether the landlord should have made the request at all. That is a brutal shift. Notice how every attempt to explain the timeline keeps creating more confusion instead of clarity. The landlord claims they didn't know about the new dog immediately. Then there are references to observations, emails, discussions, reviews of records, and delayed follow-ups. But none of it answers the judge's core concern: what authorized the recertification demand? And honestly, Judge Simpson sounds increasingly unconvinced that management had a structured process whatsoever. Without a written policy, every decision starts looking discretionary. Once decisions appear discretionary, courts naturally begin wondering whether tenants are being treated differently from one another. That's the phrase property owners never want floating around a courtroom: treated differently. Because once unequal treatment becomes part of the discussion, fair housing exposure moves from hypothetical to potentially very real.
It was prior to.
It was several months after she removed the. She was observed with the Chihuahua, and that's when she was asked about it. She never came to
That was 11 months after.
Yeah, but we didn't know that she had the Chihuahua at that point in time.
Is there a policy regarding this at all, Mr. Landlord?
Is there a policy
A
with
written policy? What places the tenant on notice that this has to happen?
we
or
notify them?
Or you can't do that, Mr. Weiss. She's under lease.
I understand. The pet agreement. I don't know. Pet agreement. There's nothing in the pet agreement that references it, but it also doesn't reference ESAs in a pet agreement. So ESA is a part of the fair housing.
Right.
Okay. There's nothing in the fair housing. I understand.
I'm trying to figure out what triggers the landlord to ask. And with that, what places the tenant on notice that the landlord can ask and then needs to comply with something?
Well, they have to inform us that they have a pet. Okay. If they're claiming that they have a need to have that pet classified as an ESA, emotional support animal.
The courtroom has now reached the critical legal crossroads of this entire case. The landlord is trying to blend two separate obligations together: registering an animal under lease requirements versus proving continued medical need for ESA status. Judge Simpson keeps separating those concepts apart like a surgeon, and the plaintiff is struggling to reconnect them. That distinction matters enormously. A landlord absolutely may have procedures about animals being registered on the property. But the court keeps emphasizing that this case wasn't really filed over simple registration. It was filed because management wanted renewed ESA-related documentation tied to the tenant herself. And the judge is hammering one devastating point over and over. Where was the tenant ever told this could happen? Where was the notice? Where was the policy? Where was the recurring timeline? Without those answers, the plaintiff's position starts looking legally unstable. You can almost feel the landlord's attorney realizing this hearing is no longer about winning unpaid fees. It's becoming about minimizing damage before the court issues findings that could create even bigger legal headaches later.
They have to go through the procedures as set forth.
Okay, but that's apples and oranges.
No, I don't think so.
Well, it is, because she's not here because she failed to notify you of the dog.
No, she's here because
She's here, at least what the landlord's saying is because the landlord made a request for the doctor to indicate that she needed an ESA.
the continued need.
And what gives the landlord the right to ask her that once she has already given it? Under what authority is the landlord requesting that?
Well, as I said, the ESA has no law either way. As far as
Either way,
requiring
in terms of what?
recertification or not.
Here's the landlord's problem.
I know what the landlord's
Yeah.
problem is.
If the landlord said, okay, every year, for those that have an ESA, every year you must recertify the need. Fine. Even if then there's a late request, the landlord has something to say, I can make this request. So the time period doesn't necessarily matter. But as I'm looking at this from what I'm hearing is, had the pit bull still been there, there would have been no request from the landlord to do anything.
Maybe.
Well, that's not a maybe. For the 3 years, 19, 20, 21, and 22, 4 years almost, that the pit bull is there, there's been only one request or one submission. They didn't ask each year.
No,
This may be the moment the landlord's case truly collapses. Judge Simpson has now locked onto the strongest fact favoring the tenant. For nearly 4 years, there was no recurring certification demand whatsoever. No annual reviews, no 6-month checks, no policy reminders, nothing. Then suddenly management wants updated documentation only after circumstances change with the animal itself. That timing is catastrophic for the plaintiff's argument because it makes the process look reactive instead of standardized. Courts can tolerate strict policies. What they struggle with are inconsistent policies applied unpredictably. And listen to the judge's wording here. He keeps returning to notice. Could the tenant reasonably know recertification might later be demanded? If the answer is no, then enforcement becomes very difficult to justify fairly. At this point, Judge Simpson isn't simply questioning the landlord's authority, he's warning them. The repeated references to fair housing concerns and differential treatment are practically flashing red warning lights across this entire courtroom.
but what
There's not even anything, Mr. Weiss, unless you can point me to something that says, okay, periodically we will request X. Is there anything that says that would place the tenant on notice that the landlord could make the request?
not that I am aware of right now, but if I can point the court, before it makes a ruling, take a look at the email threads from Fair Housing and from Group 5 and Group 5's attorneys.
But what are those email threads going to do for me?
It would show that this was discussed. It was discussed with Ms. Bell.
Okay, I get it. I get all of that's discussed. Just, and if necessary, I would take a look at it. What gives the landlord the right to do it in the first place? What gives the landlord the right to say anything that makes that discussion happen?
There's nothing that says that we can't ask.
Mr. Weiss, you can turn my question around all you want,
I know.
but it doesn't get you anywhere.
I used to be very good at that. You know that.
I know. And I expected that's what I'd get as an answer, but that's not an answer. I mean, here's the tenant who's saying, look, I have this ESA. I have this dog. Something happens with my dog. Let's say the dog didn't have to be removed from vet, but let's say the dog passes away. She gets a new dog. Would the landlord ask then for that? But they didn't, even in this case.
Not for a year later.
The hypothetical examples are starting to expose the weakness in the plaintiff's position even more. The landlord tries introducing extreme scenarios, cows, elephants, tigers, hoping to justify management's right to question ESA situations after an animal change. But Judge Simpson immediately narrows the issue back down to reality. This case involves another dog, not an exotic threat to the property. And that matters because the court keeps stressing the same principle. The tenant's ESA status was connected to her documented condition, not specifically to one exact dog forever. The landlord needed a structured, legal, or contractual basis before demanding new certification. So far, the judge still hasn't seen one. What's fascinating here is that the plaintiff's attorney appears to recognize the danger too. The more the court talks about policy gaps and unequal treatment exposure, the more cautious the entire tone becomes. This hearing is no longer about collecting fees. It's becoming a courtroom warning shot about how dangerous unclear ESA enforcement practices can become for landlords.
And then the question becomes, why did they ask a year later? Second thing is, under what authority did they ask that could affect this tenant's tenancy?
Well, as Mr. Herbeck had indicated, we didn't know about the dog, the Chihuahua, until long after she got it. It was seen.
But you're not certifying the dog.
I understand that.
If I get if you were certifying the dog and it was the status of the dog that grants that authority or that position of the tenant, I get that then. But you're not doing that. You're not even, what you're doing is you're certifying, or essence, asking for certification from the tenant. So at what point, and obviously there is nothing in writing, at what point does that expire? At what point does is the tenant obligated to do anything?
Let me pose an absurd situation.
Besides this one?
Yes.
Okay, go ahead.
Let's say the pit bull is removed and she decides to get a cow instead of a dog.
Okay.
Don't we have the right to question that as an ESA? Or do we? It's an absurd question. I can go hire an elephant or whatever. But we do have a right to review that situation.
I think you might have some justification if somebody had a dog and now has a cow. Or if they have a dog and then they get a tiger. I mean, I get that.
Judge Simpson is drawing an extremely important legal boundary here. And honestly, it's the boundary the landlord probably needed to recognize before ever filing this case. The court is basically saying, if the replacement animal fundamentally changes the nature of the situation like a tiger, a cow, or some dangerous or disruptive circumstance, then maybe management has a stronger justification to step in and reevaluate things. But that's not what happened here. The tenant replaced one dog with another dog. That destroys the dramatic changed circumstances argument the plaintiff was hoping to lean on. Because now the court sees this less as a safety or property issue and more as a question about whether management improperly challenged the tenant's ESA status without a clear procedural basis. And notice how the judge keeps returning to structure. Courts love structure, written procedures, defined timelines, neutral enforcement standards. Without those things, decisions start looking selective, and selective enforcement is exactly where fair housing claims begin to grow teeth. At this point, the plaintiff's attorney looks like he's trying to slow down a train that already left the station.
But all I have, Because at that point, though, your issue, the cow, and I'm not into answering hypotheticals, but your issue becomes that animal on our premises.
In part, yes.
Well, no, that's going to be if it's a cow. I hope that's really your major concern.
Yes.
But in this case, it's a dog. And so it's not the issue of there being a dog. It's the issue of whether she needs an emotional support animal. But she's already answered the question, and the landlord doesn't have a procedure upon which they can make the request. Because the cold-hearted reality is, because of fair housing and other things, I'm telling you, Mr. Weiss, your client's going to be without a structure to it.
Without a what?
Without a structure to when they make the request or require the tenant to do something, they're placing themselves in a difficult position. Almost to the point, quite frankly, that I don't think you want to win this case because there's going to be a bigger fish for your client to fry.
With fair housing?
With the fair housing claim.
Whoa. That statement right there should have sent absolute panic through the plaintiff's side of the courtroom. Judge Simpson is no longer subtly hinting at fair housing exposure. He's openly warning the landlord that continuing this case could backfire hard. And when a judge starts cautioning a plaintiff that they may not actually want to win, you know the situation has become dangerous. Think about how unusual this is. The court is essentially saying, even if the landlord somehow succeeded on the narrow issue here, the broader implications could expose them to much larger problems involving discrimination, inconsistent ESA treatment, or unequal enforcement practices. That's enormous. And honestly, the judge's logic is pretty straightforward. If there's no lease provision, no recurring recertification policy, no written structure, and no evidence all tenants were treated similarly, then why was this tenant suddenly challenged after years of silence? That question is hanging over the entire case like a storm cloud right now. Question for you watching, do you think the landlord genuinely believed they were following proper procedure, or do you think this case should never have been filed in the first place?
Because nothing's here. Nothing. Nothing the landlord is doing. First of all, does the landlord show me any contractual right exists for them to do?
Not that I am aware of. There's nothing in the pet agreement nor nothing in the lease.
At least you have to register now.
Yeah. In this situation, well,
But you're not,
That's
they
not
have
the
to
issue.
register the animal, but we're all in agreement that the animal isn't the issue.
in this situation, no.
Right. It's not the animal. It's her. It's whether or not she needs the emotional support animal. So, and then you're trying to charge her from back when?
October of 23.
Okay, so
This case has been going on a long time.
but this case has only been going on since May for
Yeah.
me anyway. But I don't see it. I just don't. I mean, if somehow or another the landlord were able to say, oh, let me back that up. What really has happened in this tenancy is the tenant has brought forth documents that place her in a certain status, right?
Now Judge Simpson is basically teaching a masterclass on what the landlord should have had in place before any of this escalated into litigation. Listen carefully to how he structures it. The judge isn't necessarily saying landlords can never require updated ESA documentation. What he's saying is that if they want to do that, there must be a predictable framework governing when and how those requests occur. That's the key difference. He starts laying out examples: periodic renewals, status-triggering events, written procedures after an animal dies or is replaced, clearly defined tenant obligations. In other words, a transparent system that applies equally to everyone. But according to everything presented so far, that system didn't exist here, and that absence is devastating for the plaintiff because courts often evaluate fairness through consistency. Without structure, the landlord's actions begin looking improvised rather than policy-driven. You can tell the hearing has shifted completely. Nobody's really debating pet deposits anymore. The court is now focused on procedural fairness, housing compliance, and whether the landlord accidentally wandered into discriminatory territory.
Now, the landlord in that instance, as they have to do with many different things, has to have something in place that says if X happens, if there's a change in status, or that at some point periodically you have to renew with us the fact that you still get the benefit of that status. Or this is how you lose that status. But can you get it back? If the landlord had something in place that said, okay, you get this status, and it's clearly not the case here, but you get this status with this animal. Upon the removal, death, whatever of this animal, then you have to renew your status.
Well, doesn't that contradict what you just said?
Pardon?
Doesn't that contradict what you just said?
No, I don't think it does. It only seems to contradict it because you're not really certifying the animal.
Exactly.
You're certifying the person. But those were hypothetical situations that I was giving just now,
okay,
where the landlord could have certain things in place that then would require the tenant to do something, or require at that point, maybe even obligate the landlord to ask that you provide this information or whatever. But here, that's not what's happened. She gains whatever that status and the benefits of that status. There is nothing, I don't think, or nobody's shown me anything that changes that. That's the status she's in. The landlord then can't come along and say, oh, well, now you got to do this.
This may be the strongest statement Judge Simpson has made the entire hearing. He's essentially saying the tenant's ESA status remained intact because nothing presented to the court legally altered that status. That's huge. Because once the judge reaches that conclusion, the landlord's entire recertification argument starts collapsing underneath itself. The court keeps emphasizing the same core issue. If ESA status belongs to the tenant rather than the specific animal, then replacing one dog with another doesn't automatically reopen the entire certification process. At least not without policies, procedures, or contractual language establishing that requirement ahead of time. And honestly, the plaintiff's attorney now sounds less focused on winning and more focused on preserving the ability to appeal later. That's usually not a great sign in the middle of a hearing. Meanwhile, Judge Simpson keeps warning about dangerous waters involving unequal treatment. That phrase matters. Because once a judge begins contemplating whether one tenant was singled out differently than others, the legal risk expands dramatically beyond the original dispute.
Had the status had everything attached to the pit bull, to the animal, as opposed to the tenant, then I get it, what the landlord's doing. Because now you have a new animal. Now I can ask about that animal. Not what happened here.
can I ask a consideration? Whichever way you're going to rule, can you make it in a written opinion? Basing it on what you said in court today,
Well, I would,
in case my client wants to appeal it.
that's fine. I mean, I'll give an oral ruling. You can prepare whatever order you want. You can appeal away because the landlord doesn't have a status here. Or I could rule in favor of the landlord and then let you face the fair housing suit. Do it that way.
Another attorney has to worry about that.
But this issue,
No, I understand what you're saying.
somebody has, well, let me ask this then. Does the landlord have anything that forms the basis of their request to ask this tenant for that second doctor's note?
I'm not aware of it. Are you correct?
Well, as I said, you know, she never did come forth to the office to register the animal. It wasn't until several months after she got rid of the pit bull and she was saw with this other dog. That's when we first made contact with her to register the animal. Here we are today.
Did she register the animal?
Never, no. She has not
But
registered.
the animal isn't the issue.
I understand, but she still hasn't complied with the pet agreement portion. So therefore,
Which portion?
she signed a pet addendum for the pit bull. When the pit bull was removed, she never re-registered the Chihuahua.
Well, you didn't ask her to register the Chihuahua.
Yeah. Well, we did,
No, you didn't. That's not what you asked.
not in this particular case, but
Yeah,
as a
not
side
even,
issue,
you didn't ask her to register the animal.
not for the ESA purposes, but she still has to comply with the lease, which
But if
requires.
that's what we were here for, Mr. Wise, fine, but that's not what we're here for. I
But
mean, I would absolutely agree with you with that previous scenario about the registering of the animal. But this issue is independent of the animal.
right.
Judge Simpson just shut the door on the plaintiff's fallback argument. For several minutes now, the landlord's side has tried pivoting toward the idea that the tenant failed to properly register the replacement dog. But the judge refuses to let the hearing drift in that direction because that's not the issue the plaintiff built the case around. And honestly, that distinction may have saved the tenant here. If this had originally been framed strictly as a lease registration compliance dispute, the courtroom conversation might look very different. But because the landlord tied the dispute to ESA documentation and continuing medical need, the court immediately moved into fair housing territory. That's why the judge keeps saying the case is independent of the animal. The conflict became about the tenant's protected status, not merely paperwork regarding a pet. The plaintiff is now trapped by the way the case was framed from the beginning. Every attempt to redirect the argument keeps running into the same wall. The landlord questioned ESA necessity without a clearly defined policy authorizing that challenge.
But would we still have the issue if she registered the Chihuahua? Would she have to reclassify that as her ESA animal? That's one way you're looking at it.
But did you ask her to do? But see,
We asked her to
hold on a second,
register.
hold on now, because I'm not going to go down that path with you. Because what the landlord hasn't come in about the animal. That's not why we're here.
Well, yes and no.
No, because you're here because of her status.
Well, the case was originally started for non-payment of the pet fee and non-payment of the pet deposit. Was the basis of this particular lawsuit.
Right? But effectively, all of that was suspended is in the
Was
best
it?
light for you, was suspended because she had an ESA and was in need of an ESA. But then at some point, which just doesn't seem to fit into anything logical, she's asked to renew that status. And I think the problem here, even if you had a time period of every 4 years, are there other individuals that you've treated differently regarding that ESA? That's the dangerous.
I knew you were getting to that.
Yeah, because that's the dangerous waters that your client is in right now. And that's what I was saying at the very beginning, because if I rule for your client, I have a feeling they'd appeal, it'd go up, that would come right back to me for a specific finding of was she treated differently? And then your client's got a whole lot of other problems, the least of which is an ESA on this property.
This hearing has officially reached damage control territory. Judge Simpson is practically begging the plaintiff to reconsider continuing this lawsuit. Think about how extraordinary that is. The court is warning the landlord that even if they somehow push forward successfully, the resulting findings could expose them to much bigger problems involving fair housing compliance and discriminatory treatment allegations. And honestly, the judge sounds frustrated that the plaintiff may not fully appreciate the legal risk they're carrying here. Once courts start discussing whether tenants were treated differently, property owners can suddenly find themselves facing scrutiny far beyond one disputed tenancy. Policies get examined. Procedures get examined. Patterns get examined. The landlord's attorney now shifts heavily toward preserving appellate options and written findings. That's usually the sign of someone preparing for strategic retreat rather than courtroom victory. Meanwhile, Judge Simpson continues emphasizing something incredibly important. If the landlord lacked structure governing ESA recertification requests, then the court may ultimately interpret the demand itself as improper from the start.
Okay, so basically, if I can paraphrase your thinking, Your Honor, you're dismissing this case.
I'm not. When Mr. Weiss, you know how I am. When I'm ready to do something, I'll tell you what I'm going to do. I don't know. I think as we've gone through this, I don't know that you need me to do it. The right thing to do would be for the plaintiff to dismiss it. And more importantly, then institute and formulate a policy by which you're going to handle these types of situations. Because and part of my reason for saying that is, even if I dismiss, I'm unclear as to this, but I don't know that alleviates the potential jeopardy for your client.
Well,
under fair housing, because it becomes the issue of not always am I successful in what actions I take, that I'm taking certain actions that may be in violation of that and or discriminatory.
yeah, but if the courts would dismiss it, or find no cause of action, let's say, and I would write in an opinion, or not opinion, prepare an order to that effect, setting forth your reasonings for that. That would be could be a basis if my client wishes to appeal.
You can feel the tension completely change now. The plaintiff's attorney is carefully trying to maneuver toward dismissal while still protecting the landlord's ability to appeal later if necessary. But Judge Simpson keeps making one thing crystal clear. If this hearing fully proceeds into findings about why this tenant was targeted for recertification, the results may become very uncomfortable for the plaintiff. That's why the judge repeatedly references jeopardy and fair housing exposure. The court seems deeply concerned that the landlord lacked neutral enforcement standards and may have acted inconsistently. Even without formally ruling on discrimination, those observations alone could create serious downstream consequences. And honestly, this is a fascinating courtroom moment, because both sides now appear to recognize the same thing simultaneously. The case is no longer worth the risk. The tenant doesn't want ongoing harassment. The landlord doesn't want damaging findings. The judge doesn't want a poorly structured policy dispute turning into a larger fair housing controversy. That realization is pulling everybody toward the same destination: dismissal.
That's all I'm asking.
Oh, yeah. That's what they want to do.
Yeah.
I
No, obviously,
don't really care, but
no, I understand.
I mean, I think there probably needs to be a discussion for you and your client as to where they're putting themselves.
That's a separate issue.
No, depending on what I do.
But if you dismiss it or find, no, this is a hearing on the merits. If you find no cause of action, based,
Well, but Mr. Weiss, I'm going to need to then take some testimony, because there's going to be a question in my mind that I would have to resolve as to why this tenant why they made the request of this tenant. And I don't think you want my finding on that.
can I have a brief recess with
Yeah.
my client?
Or we'll stand in recess.
Good morning. I had a chance to discuss this with my client. At this point in time, we will dismiss the case.
All right.
With one proviso, which doesn't have to be
Of
permitted.
course.
I requested that the dog be registered.
And there it is. After all the tension, all the hypotheticals, all the warnings about fair housing exposure, the plaintiff finally pulls the plug and dismisses the case. Honestly, this outcome started feeling inevitable once Judge Simpson began openly questioning the landlord's authority to demand ESA recertification in the first place. The risk-reward balance completely collapsed for the plaintiff. Pursuing unpaid fees was no longer worth the possibility of creating a much larger legal problem. What's interesting, though, is that the landlord still tries salvaging one thing: registration of the replacement dog itself. Notice the careful wording now. Suddenly, the conversation is no longer about challenging ESA status or demanding medical recertification. It's just about getting the dog registered with management. Massive shift in tone. Massive shift in legal exposure. And the judge immediately reinforces that distinction for everyone in the room. Status remains unchanged. The tenant keeps the ESA protections. The remaining issue becomes administrative, not medical. That pivot may have just saved the landlord from a far uglier courtroom outcome.
Not calling it an ESA or not, just that they have to go in the office and register the dog.
But upon registering her status,
Status is not changed.
Okay.
Right.
Ms. Bell?
Sir.
First of all, do you have any objection to the dismissal?
Providing they're gonna leave me alone.
Oh, I didn't ask you that. Do you have any objection to the
I don't
case
have any
being?
objection.
Okay, now, hold on, Miss Bell. You sat there so patiently before, you just wanted to yell at me, didn't you?
No,
All right. So then the next thing is that will you get the dog registered with them? That's not gonna change your status, meaning everything's gonna be like it is. They just want the dog registered, which probably is appropriate.
But Judge Simpson, we had actually given them a letter from Dr. McAvoy months ago
When I
stating
first got.
stating that the dog that she's saying that she's supposed to have an emergency.
Hold on. I think that issue's over. Right? So
Well, he's asking me to send him an email from Dr. McAvoy.
I just read,
well, if you look, folks, they're looking to dismiss the case.
Mhm.
They didn't ask me anything about an email. The only thing that they're then asking is that you register the dog. And Miss Bell, you don't have a problem doing that, do you?
No, I can do that again.
Pardon?
I can do it again.
Did you already register the dog?
Yes.
we're not showing it.
You're not showing it registered, sir?
I checked it.
Oh,
Oh, okay. Well, whether you did it before or you have to do it,
I'll do
let's
it
get,
again.
you'll get the dog registered.
Yes.
All right. Under those terms.
and the dismissal, Your
All right, case
Your
dismissed.
Honor,
Yes, ma'am.
one thing, I just got out of hospital again, and this is my only transportation right here. Cause she's got to go back and forth to the doctor because she was in a car accident. So it's hard for me to get anywhere because I have to go on this. So could you just bear with me for a minute? Now, she said she's gonna try to email her or whatever.
Okay, you mean in terms of registering the dog?
Yeah,
Okay. Tell you what, get the dog registered the next 2 weeks.
okay.
Okay, fair enough. All right.
What an ending to this hearing! After nearly 40 minutes of legal back and forth, Judge Simpson ultimately steers both sides toward the cleanest resolution possible: dismiss the case, preserve the tenant's ESA status, and simply require the replacement dog to be properly registered with management within 2 weeks. And honestly, that outcome tells you everything about how the court viewed this dispute. The judge repeatedly made clear that the landlord lacked a structured policy governing ESA recertification requests. Without written standards, timelines, or consistent procedures, the plaintiff's position became increasingly vulnerable, especially once fair housing concerns entered the conversation. At the same time, the court also acknowledged that landlords still have legitimate administrative interests regarding animals on the property. That's why the final resolution focused narrowly on registration instead of questioning the tenant's continuing need for emotional support accommodations. The biggest takeaway from this case: structure matters, policies matter, consistency matters, especially in housing disputes involving protected ESA status. One unclear procedure nearly turned a simple fee disagreement into a potentially massive legal headache. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.